contractors need to do after the shutdown. I'm PCI's John Clickey, joined today by our experts, Franklin Turner and Alex Major. Before we get started, I want to go over some housekeeping announcements. During the program today, I'm going to post some polling questions. You need to answer these if you need CPE or CLP credit, and you are eligible. The first one asks, how much government contracts experience do you have? 20 plus years or some other number below that. There is a right answer to this question. It's just different for every single person. In addition to that, during the program today, I'm going to give out 2 passwords. You need to collect these passwords. They'll show up as a poll, but you need to take them down somewhere that is not the poll. That's just there as a visual aid. You need to submit these passwords under My Certificates and Courses on our website if you need CPE or CLP credit. In addition to that, during you'll be sent a regular certificate of completion after the program has concluded. We also invite your questions today. Questions are an important part of today's program. We're only spending the first 50 minutes or so of the program covering content, and then the remaining 10 to 15 minutes are going to be for your questions. So if you have a question during the program, put it in the questions panel or hit the raise hand button at the end of the program, and I will give you control of your own microphone so you can ask your question aloud. There's a copy of the handouts available in the handouts panel today. I have a second polling question on your screen answering where do you work? This is really helpful information for Franklin and Alex because he will focus on different things if we don't have anyone from the government or we have a fewer or more large or small contractor people with us today. All right. Thank you all for joining us. Take it away, Alex.
Thank you very much, and thanks for joining us, everyone. So today I will introduce my colleague Franklin Turner, and he and I are going to discuss what to do now that the government's back open. So what you as a contractor should be doing, and how you should be doing it. Franklin, want to introduce yourself?
Sure. Yeah. No, thanks very much, Alex, and thank you as well, John. And good afternoon, everybody. And we'll go to who we are in a second. Actually, if we can go over to the next slide, you guys can get a little bit of background about us. But we are partners and the co-leaders of the Government Contracts and Global Trade Practice Group at McCarter & English, which is a firm spread all across the country, north of 400 lawyers. We're headquartered in the DC office. Some of you may have participated in our classes in the past. We teach, write, and speak on a variety of different issues affecting the government contract space, and work essentially with anything and everything having to do with selling services and goods to the federal government. So litigation, protest, compliance issues, regulatory counseling, teaming, JV, small business issues. Clients range from the biggest in the world to smallest shops, right? We've worked basically across the board in connection with just about every federal agency, and have handled thousands of contracts over the years. So we have obviously sort of been around the block, and that's to say, when you have questions, ask them, because we'll answer them, and we'll certainly want to make this as useful as we possibly can. We go through it, raise your hand, ask questions, put them in the chat. We will see them, and I promise you we will do what we can do to answer them. All right, Alex, back to you.
Excellent. So what we're going to talk about today, we're just going to give you guys a little bit of an agenda, a little bit of a roadmap. We're going to talk a little bit about what the shutdown was. If you didn't know about it, it happened. It was pretty epic in terms of timing. Then we're going to talk about how shutdowns can affect and did affect contracts, and then where to go now that we've reopened, things like REAs, and then tips for negotiating with the government if you are in this position. We know many of you are. And then finally, we're going to kind of open the floor for questions and proceed accordingly in that vein. So let's talk a little bit about the shutdown. So, the government shutdown occurred it happens pretty frequently because Congress failed to pass appropriations legislation for the 2026 fiscal year by the end of 2025 or September 30th. This failure caused a funding lapse leading to the shutdown as of October 1st, 2025. Everybody knows it. It's unfortunate, but it's a routine occurrence when Congress can't meet its funding obligations, and it often results in a temporary suspension of non-essential government services, right? This one was a little different because it's the longest ever. It lasted 43 days. So from October 1st through November 12th, the government reopened on November 13th after Congress finally passed continuing appropriations, which funded the government through January 30th, 2026. So, you know, again, hopefully they can get their act together because stranger things have happened. But it's only funded through government through January 30th of 2026. And you know, any further appropriations are going to be needed to prevent a future shutdown. So we've got to do it again. The government funding mechanism through CR or appropriation bills is sort of a critical area to monitor, as some of you and many of you are. And don't worry, because the news is doing that for you as well. But you know, from on the legal context as we're talking about it today, you know, you really need to be prepared for this because it is a little bit too common of an occurrence. So you need to recognize the implications of what a lapse in government funding does to your existing contracts, and then better understand how they're going to experience or how to address work stoppages, delays, and uncertainty in payments. And that's what we're going to be talking about today.
Yep. And so if you think about just the breadth of the agencies affected here, it's essentially anyone and everyone, right? Interior, State, Commerce, the Justice Department, Housing, Energy, DHS, HHS, SBA, DOT, all across the board, right? There's certain agencies that were essentially spared, but only really subsets within those agencies, right? So like the Postal Service, Social Security Administration. We have TSA listed here because they did maintain a skeletal workforce, but anyone who tried to fly during the shutdown probably knows that that was not the easiest thing in the world to do to get through airport security. 900,000 folks were furloughed. Which means what, right? On the contract side, chances are, if you reached out to anyone during the shutdown, you probably got an auto reply or heard nothing at all. In all likelihood, you have invoices that have piled up. You might have been told or otherwise encouraged to have your employees continue to work even in a non-pay status, which is not a good thing. And we can talk about that in a little bit and how to kind of move how to address those sorts of issues. And then, of course, you likely receive stop work orders, right? And there's a very specific set of things that you should do when you receive those orders, that you should track when you have received those orders, and then that you can do to the extent that you have resumed work on these contracts in terms of requests for relief during the shutdown, right? All right, next slide. Yeah, so the economic impact here was huge, right? Huge. Obviously, there's lower consumer spending, right? Because a lot of folks didn't have the money, you weren't getting the paychecks. And when you have a delay in federal spending, at the very least, there's a loss of private sector income, which then in turn lowers the demand for goods and services, right? So there is a loss of the GDP during the shutdown, which is also huge. The estimates, at least that we can tell so far, are that the shutdown caused the loss of $11 billion permanently, although some estimates are even higher than that. There's a lot of media reports with respect to SNAP recipients and folks who need the supplemental nutrition and assistance to live, losing their benefits during the shutdown. Also, consumer sentiment went way down, flights down, obviously a lot going on the contract side, which is why you're all here. $800 million as an estimate. And we actually think that that's a low estimate compared to sort of reality. Have kind of come at risk. And it's not just from the cost side, it's also from the schedule side. And there are different ways to recover cost and schedule impacts, which we will talk about. But as we all know, if you're not getting paid, your employees likely faced furloughs, even cuts to the extent you were still trying to pay your employees from whatever residual float you have in your schedule. And then layoffs, of course, with the greatest impact falling to who? Those who can least weather it the best, right? The smaller companies out there. The early estimates are that over 60,000 workers as a floor, again, outside of the federal government, lost their jobs due to the economic effect of the shutdown, although we won't get more firm data on that for a month or two. Okay, next slide. All right, so what happened to your contracts, guys? And this is the time, and I'll just say, right, so we're gonna go through some of this. Really want you all to ask questions. Put them in the chat. We will answer them. We're here. We teach on a lot of different issues. We want to make this useful, right? I mean, we'll go through some of the regulations. We'll go through kind of the best practices. But the best thing we can do is try to help you all with your actual questions. So to the extent anything has hit your company, anything has hit your organization, and you're wondering, what do I do? How can we move forward? Ask the question, right? If we can't address it in a public forum.
Or better yet, maybe it happened to a friend's company, or a friend has a question. Everything is non-attribution. Yeah. So
that's right. That's right. We again are here to help. Okay. So chances are, right, if you had performance that had to stop during the shutdown, you probably received a stop work order, right, which is distilled at 52.242.15, which is a formal written directive from the KO to halt all or part of a project, right? So when you receive a stop work order, what are you supposed to do? Stop work, right? And the temporal sort of the band in that order is up to a period of 90 days. You're supposed to stop all work due to the funding lapse, right? Which means minimize your costs, pause work during the duration of the stop work order, tell your subcontractors to stop work, and make sure that you're not doing anything else, right, while you're under the stop work order, that you're not actively charging to the contractor in any way, doing anything that the government has told you not to do, right? So if you're working, even after a stop work order, there's no obligation the government has to pay you for that work. But the chances are also pretty high that you've incurred costs as a result of that stop work order, and there is a mechanism to recover those costs. Alex, we can go to the next slide. We'll talk about kind of the machinations behind cost recovery through the equitable adjustment process. Yeah, here, if you can, just one slide up. So what does it say, right? KO may at any time, by written order, require the contractor to stop all or any part of the work called for by this contract for a period of 90 days after the order is delivered to the contractor. And then it can also be extended, right? So if we just stop at that first part, right, there's a chance that to the extent that you guys were previously under a stop work order, in all likelihood, the order has been lifted now that the government is functioning again. But maybe not. Right? Maybe the order is still paused. So if it is still paused and the government is now back open, obviously it makes eminent sense to reach out to the contracting officer to get further clarity or guidance as to the expected depth or breadth of the continuity of the stay of the order, right? So you know what to do, right? So you know what the next steps are. It also says the requirement here is that you that in the body of the order, it needs to call itself a stop work order. It needs to cite the clause. And after you receive the order, you have to comply with the terms and take all reasonable steps to minimize cost incurrence allocable to the work covered by the order during the period of work stoppage, right? So within the 90-day period after the stop work order is sent, or then any extension, the KO is then required to either cancel the stop work order or terminate the work covered by the order in a couple of different ways, right? They can either do it for default, which would be crazy if it's just a stop work that was issued due to a lapse of funding, right? The contractor did nothing wrong. Or terminate it for convenience, in which case, obviously, there's a way to recover T4C costs as well, right? Wind down costs, pre-termination costs, et cetera, depending on the text in the contract. So if we can go to the next slide.
Yeah, just and really quick, recognizing as well that yes, the government is currently open, but just know that if you want to look at it as anything, it's sort of in a pop-up stage. So the reason it's important to understand how and or whether if these clauses impact you, all you have to do is look to the end of January and figure out why you need to be kind of understanding what we're talking about here. Yes, the government's open, but it's not permanently open. It's just, operating under a CR. So
that's right. if the order was issued under the clause and it's canceled, right, or it's lifted, it expires, contractor's supposed to resume work. And the KO here is required to make an equitable adjustment in the delivery schedule or contract price, or both, and the contract needs to be modified in writing if the order has resulted in an increase in the time required for or in the cost properly allocable to the performance of any part of the contract, and this is critical, the contractor asserts its rights to the adjustment within 30 days after the end of the period of work stoppage, provided that the KO could extend that period, although I wouldn't count on it here, if it determines essentially in its sole discretion that the facts would allow that. So let's just kind of break this apart and think about what it means for you all, just kind of mechanically, right? If the stop work order has increased your schedule or your cost on the contract, you can get relief, right? Clause requires the government to make an equitable adjustment, but the government's only required, right, to make an equitable adjustment if it agrees with your request for relief, and it's not going to agree with your request for relief unless it is properly documented and submitted the right way. And even then, it still might not agree, in which case you can get into the claims process, which we can talk about. But the key here is, do you have evidence that demonstrates with granularity the extent to which your schedule was affected and the extent to which your costs were increased, right? What do your books and records say? Who are the employees that couldn't work? What costs did you incur? You know, were there demobilization costs? Are there remobilization costs? Are there certain overhead related expenses that were allocated to the contract that couldn't be absorbed during the stop work period? What has happened here, right? And then also from a delivery schedule standpoint, how much more time, if any, do you need to do the work, right? What was the impact? When you had to hit pause, chances are you were midstream doing whatever your contract told you to do. So then all of a sudden you're told to sit on your hands for 45 days or 43 days. That's going to hurt. That's going to hurt the schedule, right? In all likelihood. You have to be attuned to these issues, and you should be thinking about the extent to which you need to get that relief on file and requested now, right? Not later, now, because remember, that clock is ticking from the date that the shutdown expired, right? Or really from the date that the stop work order is lifted. But assuming that most folks got that order rescinded, you know, within 24 hours or so, you need to be working now to document those claims and to get those requests into the government ASAP. I don't know, Alex, you have anything you want to add on that?
No, we have a question though, or at least a comment, that there's somebody seeing payments that are still on hold for the subs, and are basically trickling down mostly to the small businesses. So,
okay, yeah. So it says payments are still on hold for the subs and are trickling down to the small. So is it? And I'm not sure that I understand the exact question. Is it proper to withhold payment if you're the prime contractor for the subs, and then at some point to start paying again? I would say terms of your contract are going to dictate, the terms of your subcontract are going to dictate when, whether, and how you are supposed to pay, right? If you have a pay when paid clause in that contract, then you pay when you're paid. Keep in mind, there are accelerated payment to small business clauses. There are all sorts of different things in there that could dictate kind of the depth and breadth of your payment obligations. So that, to me, would be a contract-specific issue. I don't know, Alex, do you have any different thoughts on it?
No, I think that was why I wanted to raise it.
Okay. All right. So, if you want to talk about the path forward, right, now that the government is reopened, chances are you're going to be seeing a lot of modification activity. And Alex, I'll pause here and I'll let you cover this if you like. Do you have anything to say about it?
Yeah. So, I would, contractors have to consider FAR 43.103 as we look at contract modifications. So, there's different ways that contracts can be modified. There's the mutual agreement, right? The bilateral side of things. But there's also unilateral. Chances are, if you're a contractor, you're not making the unilateral decision. The government will be making those unilateral modifications kind of by the contracting, solely and described by the contracting officer. Key modifications post shutdown are going to be usually include things such as adjusting schedules, adjusting costs, usually hopefully to account for the delays caused by the shutdown. So, making sure that you have that understanding so that you know what those delays are, maybe knowing the critical paths is going to be very important. There is, you need to be prepared both from a mental standpoint, but also a numerical data standpoint to provide for equitable adjustments. You have to assert your rights to equitable adjustments based on the government's failure to meet timelines due to the shutdown. It's in this regard, it's important to, you'll hear us say this a lot, but it's part and parcel to being a government contractor and then making the money that you need to make on that contract. But you have to carefully review your contract clauses and any modifications related to changes in delivery schedules or pricing, especially following disruptions like this. So you need to be ready to do that. So, why the changes clause? Really, it's, what is it really? It's really the government's right to make changes. The government does reserve the right to change the terms of contracts through changes clause. This allows them to modify the scope of the work, possibly the methods of delivery, but you need to ensure that you understand these clauses so to better protect your interests during shutdown related modifications. Are they going too far? Did they change the scope? There's a lot of changes are allowed, but if it's a cardinal change, if it's so material to the underlying scope of the contract, you need to kind of raise the BS flag.
One thing to no, just while I think about it, kind of in real time, guys. One thing to keep in mind here is that in terms of changes, right? In terms of what do we do next? Remember, when you resume work on this, you need to be taking direction specifically from the contracting officer, right? Not folks who at the site, not the coder, not folks who are sort of there at the site, but the only human being with the authority to actually bind the government. To the extent that you think you're being told to do something that's inconsistent with the contract, you're being told to do something that might increase your contract risk, right? Whether it's cost or schedule, or you have questions, right, about responding to the stop work order. And now that it's lifted about, the equitable adjustment process, et cetera. Those, one, they're a creature of contract, right? So look and carefully analyze what your contract says, but also engage with the KO, because the KO is the only one with the warranted authority to actually speak with meaning on this sort of thing in a way that binds the government. So at the very least, ensure it doesn't mean you can't talk to the other folks who are not the KOs on the side of the government, but just make sure that the KO is read into the process, right? On the emails, on the correspondence, and ultimately that you take any sort of dispositive direction from the contracting officer. It's very important, because if you take direction from somebody that's not the contracting officer, and that direction increases your schedule, time, or otherwise escalates your costs, you're not going to be able to get recovery as a matter of law, as a general matter. Okay, Alex, sorry, back to you.
Oh yeah, no, and I think that's a good point. And generally, I know that if you're on this in this call, obviously you're thinking, oh, of course, we always deal with the contracting officer. But one of the things we're finding, especially over the past 9 months, is a lot of those people have changed. A lot of those people are moving around, gone, dipped, whatever you want to call it. So make sure you understand that very basic necessity. Your core, like Franklin was saying, is not enough. Your technical representative, make sure you understand that the contracting officer is who you believe they are, and because if your mistake in that could really limit your ability to make the appropriate recovery, to make the appropriate changes, etc. So.
Yeah, also remember this, and this is keyed purely off of this slide here, but you do have a duty to proceed in the face of a dispute, right? And I think most seasoned government contractors know that, but to the extent that that you don't agree with what the government is telling you to do, the way to deal with that is by proceeding under the disputes clause, right? You don't want to walk away from the work because you get a T for D, and then, as we all know, that can have a cascading effect on your contracts and on your ability to compete for future work, et cetera. So change orders themselves permit the contracting officer to make unilateral changes. You'll see those typically processed through an SF30, Standard Form 30, and they may require separate change order accounting. Obviously, if you disagree with what the contracting officer is telling you to do, the remedy, of course, is to proceed through the disputes clause, right? Not to stop work, as I just said. I don't know, Alex, you have anything to add on that one?
No, I mean,
Okay.
I think, the change orders, you have to be, you have to have a good accounting reflection of your change order costs. So.
Yep. So in terms of the coverage of the basic clause, right, and you'll see these in your fixed price contracts. Obviously, there's variance between different contracts, right? So you might have, pure commercial clauses, you might have non-commercial clauses, but bottom line here is that they all sound in the same kind of flavor of what the government can do. This says a KO may at any time by written order and without notice of sureties make changes within the general scope of the contract in any more of one of the following areas. You're talking drawings, designs, or specs, method of shipment or packing, place of delivery, right? Sounds simple enough. We can go to the next slide. So what does within the general scope of the contract mean, right? And the reason, by the way, why we go into this and the reason why it's critical now is because you're finding your footing again after the dust storm that kind of was in, the shutdown, right? You're trying to see through the impacts of that. And the chances are very low that your contracts just remain static and were completely unaffected during the shutdown, right? And in fact, chances are high in the opposite way, right? The chances are probably pretty high that you do have issues that are going to need to be resolved through the equitable adjustment process, perhaps through the changes clause, et cetera. So it's important that you guys understand the mechanics of how to deal with this, right? Alex, do you want to recover because you had mentioned cardinal change earlier, just kind of what scope is and how kind of a cardinal change, how to know if it's a cardinal change versus not a cardinal change?
Yeah, I mean, really, when it comes to cardinal changes, this what we're really talking about are changes that effectively alter. I'm trying not to use the word in the definition. Effectively alter what you are supposed to do. So, we talk about it here. There've been case law after case law. It's a pretty standard understanding that work that should be regarded as having been fairly and reasonably within the contemplation of the parties when the contract was entered into, right? So, if you're in a position where, you were digging a ditch and now they're saying they want you to, put in, maybe fill a ditch, right? Or put in rocks or that sort of thing. When there's something like, wait, that was not what we intended. So whether it is essentially the same work as the parties bargained for when the contract was awarded, or instead altered the nature of the thing to be constructed, put together, or performed or provided. So that is where, when we talk about this all the time, when we talk about things like mission creep or scope creep, where it's just one thing after another, and before you know it, where initially you were just supposed to be digging a ditch, now you're building a dam, right? Or building a levee or what have you. But understanding what the scope of your contract is, and then recognizing where you currently are in the performance of that contract or what's being asked of you. You want to be in a position where, you have not moved yourself into or through or into a new spot or into a new space. So when you're in this position, or when they're asking of you to do certain things, or even if we're in a position where, this is supposed to be done within 6 weeks, and now they're saying, well, because of this, and you've scheduled for 6 weeks, or maybe given 8 weeks, then if because of the shutdown or because of the past 43 days, there has been some huge alteration to what you intended or what the parties contemplated or the intent of the contract, then you're kind of moving into a place where you can say that there's been a cardinal change for your particular contract.
Right, right, and the key, of course, to getting relief for something like this is understanding what your specific statement of work requires. Right, you have to be a subject matter expert in what you're actually supposed to be doing, and you have to ask yourself, what are you doing now, and does that difference frustrate any part of the fundamental bargain that we made at the outset? Right. Is your proposal, was your price proposal predicated on doing this kind of work? Was your schedule proposal built around this, right? The answer to those questions are no. There is a documented, or there is a way to get out of it as long as you have the right documents in place, right? But again, it's very, very fact specific. As we continue to move through these slides, just a reminder, guys, submit your questions. So far, I think we've had one. So if you have any more friends, or friends companies. Oh, wait, it looks like we just had another one come in. Okay, it says here, what if the stop work order occurred in the last option period, which also included the option to extend services, and the government must have the work completed? Contractors' existing resources don't allow for an accelerated schedule. The government extend the term of the contract without violating 52.217, 8, and 9. As a matter of contract law, first of all, it's going to depend on exactly what your contract says, on exactly what your proposal says, and on the extent to which the parties acknowledged, talked about, contemplated schedule extension. But typically, the government is held to the black and white terms of the option to extend services clause, right? If you have, and if the stop work order extends beyond the outer ambit of the option to extend services clause, and there is no more time left as a matter of fact on the contract, then you would need to modify to continue working on it, right? Because you'd be held to the same kind of black and white terms of the contract. I don't know, Alex, do you have any other thoughts on that?
No, I think I think you kind of hit it. I'm trying to think if there was anything that.
Yeah, it's a gray area, but I don't think they can make you keep working on this after there is no more time under the outer bands of the contract schedule, which I understand to have happened here, right? Yeah. So the typical way that I think the typical way that this is dealt with is through a mod. And in that mod, you should get, you shouldn't release anything, right? You should make sure that you are given adequate consideration for whatever it is that you need, right? You say if the contractor's existing resources don't allow for an accelerated schedule, you need to ask for whatever compensation you need to accelerate that schedule or to continue working. And if you don't get it, then I don't see how the government effectively can continue to tell you to work, right, on the contract. Be careful again about saying no and walking away and inviting a default termination, even if the contract is technically expired. I mean, there's an old federal circuit case, I think, that touched on the duty to proceed even in the context of an invalid option exercise. It's the old ATK Systems case, I believe. But the bottom line here is that you want to proceed under the disputes clause. You want to have black and white documented proof, right, that you're trying to comply with the contract, and send that to the contracting officer. And you might even need to move into claims territory if for some reason you can't get the kind of solid relief that you should be able to get.
Yeah, so. And in documenting it's going to be very important. I mean, ultimately, if you're trying to behave like a responsible contractor and meeting your obligations, and it's the government who's being obstructionist to those, to that, or trying to get more, something for free, courts will be sensitive to that. Right, that you're trying to do and meet your obligations, that you expect the government to do the same thing. But you want to make sure that you're doing everything in a compliant manner, in the correct manner, and then hopefully the government will treat you with the respect that you're treating it, or the agency.
Yeah, that's a great question, and I think we've now
Yeah.
addressed the two that have been asked. But please keep them coming. That was an excellent question. Um, okay, so what's a constructive change? Well, there's not a single definition of it, right? It's essentially you'll know it when you see it, right? It's there's a clause, right, that says that you need to notify the government if the government's that's at 52.243.7, but it also likely just is a good practice technique here. Anytime the government takes any acts or omissions that you think are changing the terms of the contract, you need to tell the government, right? And a constructive change can be everything from the government kind of, if you have a design build contract, the government's being overly pedantic on the design side and is kind of arrogating unto itself the prerogative to dictate things that are within the purview of the contractor, right? That's classic, like they're going to wrest design authority away from you. Okay, well, they've constructively changed X, Y, or Z, right? It comes up a lot, particularly if you have performance specs, right, where you're kind of given the latitude to do the design. It's just you have to meet the performance specs, but then you have folks kind of on the government side who are just overly pedantic with exactly what you're doing and how you're doing it, and they want to, kick the tires 98 times far more than what would be called for under the contract. Right? It's kind of a classic constructive change. Also, telling you to do something or to meet, certain standards or deliverables that are not encompassed by the statement of work, right? I'd like you to perform a demonstrator test on XYZ for us, or I know first article acceptance says this, but we need you to do that, right? Just different kinds of things. And we've seen in past shutdowns, and we again work with a lot of companies, a lot of different procurements over the years. These kinds of changes tend to increase in the wake of a shutdown, when everyone is kind of panicking, for lack of a better word, to get back on task, to get back on schedule, to complete the contract. This kind of happens in the haze of a shutdown. So you just need to be on the lookout for it, and you need to make sure that you raise the issue to the government's attention to the extent that that happens. The only way you're going to know is by carefully studying yourself. Okay, Alex.
Yep.
Here's another question. Actually, before we get to that question, Fritz, did you want to do a password, or are we good for now?
This is a great time for that first password. First password today is the word reef. Reef. R-E-E-F. Reef. Reef. All right. Take it away, guys.
Thank you. And could it be like turkey or something to do with, the holiday for reef? I see where you're going though, because you dream about getting away and taking a vacation to a nice coral reef somewhere. Okay. All right. So the question here is, my contract with a subcontractor includes an option with language that will be exercised on or before April 30th, 2025. The option wasn't exercised at the direction of the program manager. Now that the government's open, we have funding for the option. Can I still exercise the option through unilateral contract modification? Not if your subcontract. So the answer is, depends on what your actual subcontract says. But if the period of performance has expired and the option went on unexercised, and it says on or before April 30th, right? So we're talking long before the shutdown took hold. Again, the answer is contract specific. Sorry, Alex?
I say if the date is correct, that's what I wasn't sure if there was a typo in that date. Like it was supposed to be 9/30, so, but anyway, go ahead.
Yeah, if it was truly supposed to have been done in April, I'll tell you that'll be an uphill walk, but it also depends on what your specific subcontract says, right? What does it say about period of performance? What does it say about option exercises? No, I don't think you can unilaterally, though, tell a sub to return back to work approaching 7 months after it seems the contract has expired, right? If there's a sub that is conducive to that, I suspect you would get a large request for relief on the mod just to get everybody back at the job site or to get everybody ready to work again. That would be my 2 cents on that. Okay, yeah, they confirmed that the date is correct. Yeah, so I don't think that strikes me as very unlikely. But again, happy to chat about these specific circumstances offline. If you'd like to email us, I'm sure we can jump on a call to walk you through it in more detail. Okay, so notification of changes. We talked about this before, but basically, if you determine the government has affected or may affect a change in the contract and has been identified in such as writing and signed by the contracting officer, you need to notify the government in writing as soon as possible. Who should you notify, right? Not your friend Paul at the work site who who you see every now and then, not Janice from accounting. Who? The contracting officer. Alex, why the contracting officer?
Because they are the only ones warranted to make the changes and or requests that you might be examining.
Yep,
so
it's that simple. Hopefully that, and you guys,
you will respect their authority.
We keep reiterating that simple point, but trust that. I mean, we've had hundreds and hundreds of changes cases over the years, guys. The authority issue is a huge one, right? We could tell you how many times the government has said, listen, yeah, you did that work at risk. The KO wasn't in the loop, right? Don't let that be your situation. Notify the KO, put them on email, send them, request written confirmation, make them talk to you about the change. Because if you don't, right, then you are performing at risk in that respect. Okay. All right. So you notify.
We've used the phrase. We've used that phrase I think a couple times. The working at risk, and what the rest of it is working at risk of not getting paid. That is what we're talking about, right? You are effectively working for donations, right, or volunteering your time, energy, and actions for the United States government, and then hoping that they pay you when they're under no obligation to do so. And actually, that could open a litany of risk too, outside of not just being paid, but perhaps you might be working contrary to subcontracts or subcontractors or making promises that you are not able to keep. So, we say work at risk, and the risks are legion in that regard. So, that's why you don't want to do it. So,
yeah. And we know we sound like a broken record, guys, in this respect. It's just war stories. Trust us on this. You wanna make sure that bell is rung.
We don't want you to be a war story. That's
right. Right. No, we pride ourselves in giving pragmatic advice, right? Anybody can sit up here and read a regulation. We're just trying to tell you kind of what we see in the trenches when we deal with the government on these issues. And this is one of the big ones. All right. REAs, requests for equitable adjustments. So they are what they sound like. They're intended to make the contractor whole after a change occurs. They need to rely, right? They need to be anchored in the umbilical contract provision, the clause, right? Whether it's a changes clause, the different site conditions clauses, the service contract labor standards clause of that, or the stop work order, as you'll see here, right? So again, these are remedy granting clauses. So the first thing to know with respect to REAs is what clauses are you proceeding under in your contract that allows you to file one in the first instance, right? Your contracts, guys, 99.9% likelihood here that they are governed by the Contract Disputes Act of 1978, right? The CDA, which contemplates the assertion of claims, right? And an REA is pre-claim, right? This is trying to negotiate with the government to get you relief under the contract before having to escalate the issue to the disputes clause process. So remember, when you're requesting relief in this respect, details are critical. Provide the facts, provide the documentary support, right? You need to prove your case or to be able to prove your case, because at the end of the day, one, the government has to have a documented rationale for actually giving you the relief that you want. Two, if you ever have to perfect the REA into a claim and proceed through the disputes process, you're going to need to know what evidence you have to actually make your case, right? And again, kind of walking you through it. Say you have a $200,000 claim on a contract, and you go through the REA process. You submit a request for equitable adjustment. For $200K, they say no, You then perfect it to a claim. You certify it. You submit a certified claim. They say no, right? You get a contracting officer's final decision, says no, and then you appeal. And you go to either an agency, Board of Contract Appeals, or directly, at least under the CDA, directly to the Court of Federal Claims. You're going to need evidence, right? You will need evidence all along the way to support what you've been doing, which is why we've said, or to support your request for relief, which is why we've said, make sure that your costs are tracked, your schedule impacts are tracked, et cetera. Alex, you have anything else on that one?
Yeah. I know we're going to walk through a little bit more of this, but timeliness in this regard is crucial, right? So, you want to be prepared, and you have to be ready to do this. Even before submitting the REA, one of the things that we think is helpful, especially if you have a good relationship with your customer, is let's notify the contracting officer of the potential for an REA and the expected impact. Let's sort of, I don't want to say grease the wheels, but let's make sure that they know it's coming. It's better to notify early and then continue documenting the impacts that later support it would support your claim letter if you ever have to go that way. But hopefully it just won't come as a surprise to the contracting officer. You want to know, and you want them to know that either the stop work or the delay or whatever, it caused you specific harm, damage, cost, overruns, whatever. Don't assume that they should expect it, right? Or don't assume that they know it's coming. Let them know. Give them a heads up that, hey, we're going to be filing a request for equitable adjustment specifically for this, that, or the other thing.
Yep. Okay, let's go to the next slide. And remember, guys, keep your questions coming in, and we will get to them. So we talked about this clause earlier, and I don't think we need to spend too much time on it now because we want to make sure we leave the forum open in a few minutes. So the standard fixed price changes clause, right? It says the KO can at any time by written order and without notice make changes within the general scope of the contract, right? And that includes drawings, designs, specs, method of shipment or packing or place of delivery. If those changes cause any impacts to your time or schedule or costs for performance of the contract, KO is required to make an equitable adjustment to contract price, delivery schedule, or both, and has to modify the contract, right? So that's the typical kind of clause you would be proceeding under, to the extent you get a change request that comes in, or to the extent, a change occurs and you want to request relief on it, right? Pretty high likelihood that in the wake of a shutdown, if you're getting unilateral changes directed to your contract, there will be, particularly in the wake, especially in the wake of a shutdown, cost and schedule impacts that have not been addressed, right? Now, whether they occurred under the stop work order clause, which grants you the right to request relief thereunder, as we talked about earlier, or whether they're also tethered to this clause, right? You can proceed in the same REA citing to multiple clauses as bases for relief, right? The key is which clauses grant you the remedies, right? The right to request these remedies. And the only way you're going to know that, obviously, is by tracking your contract very, very closely. But these are the examples of what there is out there. All right, let's go to the next slide. Oh, I think we skipped over one. So, right, saying that the the contractor has to assert the right to adjustment within 30 days. It says that the KO can receive later requests and then act upon those as long as they do it before final payment, which is true, right? And we've seen that many, many, many times over the years. But here, right, particularly in the wake of a discrete event like a stop work caused by a shutdown, you're going to want to get these things on file as quickly as you can, right? All right, and then failure to agree, right, does not mean you can walk away. You're the contractor, right? You don't have the right to unilaterally terminate the contract. You don't have the right to walk away. Under the standard disputes clause in these contracts, you have a duty to proceed. The reason why, obviously, is because working with the government is different, right? You're getting paid by taxpayer dollars. The end customer is the American taxpayer. So the idea there is, yeah, you've got to keep working on this until until the issue is actually resolved. You can't just walk away. You don't want to leave the government in limbo. If you do, the chance is very high that you will get T for deed. It will have negative effects on your CPARs. It'll ripple across your base. You have to report it, right? There will be all sorts of issues that would arise from something like that. All right, let's go to the next clause. Alex, you want to tick through some of these?
Sure. Yeah. So, we just, again, as recognizing that we're talking about contracts generally, we just wanted to kind of highlight areas too that other clauses that provide recovery should you have run into problems during the shutdown. Suspension of work, usually that's going to be found in contracts for supplies, services, or your R&D contracts. There's been a lot of, if you're in the R&D space or in academia, there have been a lot of changes and a lot of new requirements for in the R&D side to include SIVR going away, et cetera. So understanding where the suspension of work, if and where suspension of work under 52.242.14 is in your contract is going to be important. In fixed price construction contracts or engineering contracts, you can look for 52.242.15. Again, just wanted to put you, let you zero in. So in non-commercial fixed price contracts, government delay of work clause, or in cost reimbursement contracts, you can also find excusable delay provisions found at 52.249. And usually it's going to be non-commercial items for fixed price contracts in that respect. For commercial items, if you are in that space, look for 52.212.4F. Really, all of these clauses, though, provide a mechanism to recover additional time or money following your contract performance resuming following a shutdown. So again, understanding which clauses are in your prime contracts or your subcontracts are imperative. And if you're a prime or if you're a subcontractor and you have questions, feel free to educate up and ask of your prime. Right? Are these clauses in the contract? If you have questions about that, just again, especially if there is a delay in payment or you're not sensing that you are going to be getting paid.
That's a super critical point, and one that I know we touched on earlier, but I think it warrants repetition. If you're a subcontractor, guys, I mean, you're not in direct privity of contract with the government, right? So your right to relief is predicated based on what your prime contract says specifically. So know the terms of that contract. Know the ways that you can kind of engage with your prime and elevate these issues. And at the end of the day, if a claim is necessary, right, even if a claim is necessary based on the government's own stop work order, there are ways you can get your prime to sponsor a claim. There are all sorts of ways that a subcontractor can get a request for relief out there. But the key here, again, is knowing exactly what your contract says. We're going to tick through these next couple of slides pretty quickly so we can get to any open questions. But as Alex mentioned earlier, you have 52.242.14, suspension of work. It basically just says that if performance is for an unreasonable period of time suspended, delayed, or interrupted by the act of the KO, right, i.e. stop work, or if the KO doesn't act within a time specified or within a reasonable time if not specified, then an adjustment shall be made for any increase in the cost of performance of the contract that's caused by the suspension, delay, or the interruption, right? What does that mean? It means you need to understand, A, whether the clause is properly invoked, right, which is going to be very fact specific, but then two, if you are going to claim relief, what are you asking for, right? What happened during performance? And why do you need the relief, and what can you do to prove up your specific request? Here, there's a timing mechanism, right? It says basically that a claim shall not be allowed for any costs incurred more than 20 days before the contractor shall have notified the contracting officer in writing as to what was happening. But it doesn't apply to a claim that would result from the suspension order. So there are there are other clauses, right, like changes, like the other typical REA clauses that are in your contracts that will give you the right to request relief here, even where in factual circumstances where this clause may not. And we don't need to belabor this too much, but it is just something to keep in mind. We've talked about stop work order clause. We can go ahead and pass to the next one. Government delay of work, right, applies pretty much the same way, right? If performance is is delayed due to what happens here by an act of the contractor, an act of the contracting officer in the administration of the contract, you can again request relief, right, through cost-specific relief. Again, you need to, as in the suspension of work context, document it, raise it timely under the clause, and in circumstances where you can't, right, or where for some reason you failed to do that, there are other mechanisms typically in the contract that should allow you relief there. All right, let's go to the next one. Excusable delays is another one. We saw this a lot during COVID. I mean, it just all over the place because of obviously the pandemic, right? And it's something that came out here. If you have quarantine restrictions, it came out quite a lot. What it allows you to do, right? One, it guards against the finding a default because, or the extent that a failure to perform is not due to your fault, but it instead is due to what? The act of the government in its sovereign or contractual capacity, right? So the government closed. The government told you to stop working. If you're losing schedule, right, which is what you can get under this clause, right? It's not a cost recovery clause. It's a schedule recovery clause. Then you can request, and you should request relief, right? And the KO will look at your request for relief, and if it agrees, if it determines that yeah, you're right, you weren't able to work, right, and you weren't able to work if you had to stop work on this. So all pencils down means, of course, there's going to be some sort of a delay to your ultimate schedule, unless you have excess float, which is really unlikely. Then the government is supposed to grant you that request for relief. So again, this is a remedy granting clause. The same is true if we can go to the next slide, Alex, at 52.212.4, the same sort of thing, right? So you saw kind of the standard clause a second ago that you'll see in a wide variety of contracts. This one also you see in pure commercial contracts, right? That's the standard 52.212.4 commercial terms and conditions. Subsection F says basically the same thing that the prior clause said. So let's move over to the next.
The big takeaway here, and we've said this again repeatedly, but just if you're relying on any sort of excusable delay, the key here is to document those delays, right? Including the cause, the impact, which would be the government shutdown. Franklin brought up COVID as a great example, but this documentation is vital when you're seeking an adjustment under this clause. So you just can't get there without it.
All right, so we're gonna wind this down, guys, on some tips to talk to the government, and then please have some more questions ready so we can help out, guys. So key hurdles to time and cost recovery post-shutdown include failure to mitigate costs pursuant to the stop work order, right? What did you do and how did you kind of mitigate any damages that happened when you got that stop work order? Untimely REAs, remember the specific timing mechanisms that we talked about, proving the causation of the incurred costs, right? Showing that that the costs actually were incurred as a result of the shutdown, right? So you need to understand the evidentiary linkage there from a documented standpoint. Demonstrating that costs were allowable under the contract, right? And then failure to provide prompt written notice. So again, right now, to the extent you have shutdown costs that you want to assert, right? You need to be doing these, this internal due diligence, this internal fact finding to make sure that whatever requests you're going to submit are properly documented. So what do you do to maximize recovery? Let's go to the next slide.
Yeah, real quick before we leave this slide, the one thing I think that's really important is that word mitigate is going to be very important. And what that effectively means is making sure that you aren't going nuts during the shutdown, right? Making sure that you took in the, did you find ways to do what you could do to minimize the scope of costs, right? You still had to perform your contract, like Franklin said, you still have a duty to proceed, but did you do or did you take any actions due to this very recognizable delay or stop work order or whatever? that's going to be an element oftentimes that becomes arguable, and you want to try to make sure that you at least tried to mitigate, but within the confines of your obligations under the contract.
So in terms of increasing your chances for success, what have we been saying, right? Document everything. Thorough documentation is absolutely critical. So, as we've talked about, you can get time extensions, you can get cost recovery, but you can't get it if you're asking the government just to take your word. You can get it if you can prove to the government what happened, right? You have to establish a documented nexus between your request for relief and the shutdown, right? Or whatever the government's change may be. So stay on top of your records. Make sure that you understand what the delays have been, what the costs have been, and that, as Alex just said a second ago, that you've done what you can do to mitigate and minimize those costs. At the subcontract level, right, whether you're the sub or the prime, you should understand what your contracts say. You should understand when and how you're supposed to stop work, when and how you can resume work, and when and how any claims resulting from that resumption or stoppage of work can be processed, right? It's going to depend on the terms and conditions in your subcontract. Again, and that applies whether you're prime or sub. Following government reopen, be prepared to start work ASAP, and then check your contracts carefully to determine when, whether, and how to submit REAs related to the shutdown. And of course, ensure that you're timely issuing any invoices that would relate to or substantiate these costs. Next slide. Alex, you want to cover these?
You betcha. So, track and document all material costs. We can't overstate this enough. Documenting makes your opportunity to collect a lot more realistic. It makes our jobs, your attorney's jobs, a lot easier. So, you want to make sure that you understand the delays and changes in the contracts, required scope, and what you did to address that. You need to track all the changes, right, including formal orders and constructive changes from the contracting officer. And when we say from the contracting officer, it's not really the best, but if it's the core, or if it's a technical representative who's telling you to do stuff, if the contracting officer is copied, we're calling that good, right? Or at least it's justifiable. It's arguable that they'd be seen as having notice. So making sure that person is on those orders, on those requests, is going to be very important. Like we were talking about, do not forget to try to mitigate costs where possible, and document when mitigation is not possible, right? So this is another example of, listen, we have certain things we have to do. There is really no way to cheapen this. There is no way to lessen the cost or the impact or what have you. And you want to basically be able, and it's better to try to do that as you're experiencing the cost or the implication or what have you, but not preferably during, but not, we can do it after the fact, but it's better to try to do that during the performance. And then don't forget to track down any overdue payments that the government did not make during shutdown. Really, you have to track those under the Prompt Payment Act. Contractors like you are going to be entitled to interests on overdue payments. So making sure you understand what those are and what you have and what you're missing is going to be incredibly important. But cannot overstate the importance of preserving communications and documenting shutdown related costs.
All right. And we've explained here why this is critical. This is kind of how to prepare, right? Whether you in terms of your documentation, right? Whether you create separate cost codes, record dates, keep copies of notice, track labor, subcontractor impact, track demob and remob costs, right? In terms of ramp down and ramp up costs, et cetera, right? And this is all stuff that we've been talking about. So we can move on here. And here we are. We are. Oh, and this is the mod reminder that we talked about earlier, guys. Just make sure that you're reading any mods carefully. If you're asked for complete releases, talk to your counsel because you need to be careful, right? Remember, under the Contract Disputes Act, you have basically 6 years. You have exactly 6 years from the date that the claim accrued to assert it, right? So you don't want to waive your right to relief if you think that it may be there. So there are ways to get narrowly tailored, narrowly targeted mods without giving up more rights than you have to. All right. With that, guys, thank you so much for your time. Happy to take any questions. I don't know, Fritz, if you have another password to put in before the questions or if you're ready.
I can give out the final password now. The final password is the word SAIL, S-A-I-L, SAIL, SAIL. All right.
All right. Folks, thank you all for your time. And now we'll stay here for a few minutes to see if there are any questions.
Hit the raise hand button if you have any questions. We did leave these 10 minutes on at the end for questions. So we definitely want them. And hit the raise hand button or type your question in. If I start threatening to turn it off, hit the raise hand button while you're typing so I don't close it before your question is answered.
No such thing as a bad question, guys. So keep that in mind. Anything on your mind, now's your chance. Please feel free to ask. And oh, here's one. On a different topic, what do you think is the future for DCAA, DCMA? You know, I don't see. I mean, I do a lot of cost work, and I kind of think of DCAA as the Will Rogers of agencies, right? It never met a cost it didn't question, and we deal with a lot of DCAA and DCMA activity. I think those agencies are going to stay around. There's plenty audits. There's plenty of audits to be done. Plenty of contractors to point fingers at. And we've seen actually an increase and uptick in DCAA, DCMA enforcement activity over the past several months. And anytime you have you know, hundreds of billions of dollars going out the door, particularly in connection with cost type vehicles and cost type work. There are increased requirements, obviously, under FAR Part 31. There are increased CAS specific requirements if you're subject to the cost accounting standards. And they're not easy. They're not all the time intuitive. So we expect there to be more confusion, and my thought there is the government's going to continue using it as kind of a money pinata as it can.
Yeah,
Alex, do you have any thoughts on that?
Yeah, no, and I think especially with the more expansive role they're playing, specifically as it relates to things like cybersecurity and DCMA, and the I would say a lot of the new requirements coming down, specifically related to domestic preference situations and sourcing and supply chain issues, they're going to be very busy. There's going to have to be a lot of education between you all or between contractors, the contracting officers, and DCMA, because of all these changes. I think there's going to have to be a lot of crosstalk, shall we say? For sure.
Another question came in, was the second password SAIL? Yes, it was. All right. Here's another one. Do you have any suggestions for planning steps just in case the government funding is not approved after January 30th, 2026? That's an excellent question. And the answer would be yes, right? Get a hold of what your contracts require now, understand your delivery schedule, near term, right? What is it that's going to happen in the spring? What are the specific metrics? What specifically must you do to comply, and create now a documented path, a documented trail with the contracting officer, raising the specific issue. Hey, we understand funding might expire on this, you know, at the end of January. What should we do? What if we have cost impacts? What if we have schedule impacts, right? Get the government on record here. If you do it now, then I think your future requests for relief or help will be much easier and much smoother even in the claims context, because you will have a documented record. All right, anybody else? Yeah, here's one. Oh, I just got, someone has a hand up. Okay, sir, I don't know if you can unmute yourself, but feel free to go ahead and do that, and we can answer your question.
He can't yet, but he will in just a second.
Okay.
If he can re-raise his hand, I need to be able to see it. Chris, you now have control of your own mic.
And feel free to go ahead and raise your question. We're happy to help. In the meantime, we did get another question that says, have you seen these in government contracts recently? And it says, in consideration of the modification agreed to herein, contractor released the government from any and all liability under the contract for equitable adjustments attributable to facts or circumstances giving rise to the incorporation of the changes herein. Yes, is the answer. See that with some degree of regularity, and there are ways to modify that, or there are ways to get the government to agree, at least in our practice, to only to have that adjustment tailored only to the known or reasonably knowable impacts, right, as of the date that you're requesting the relief, and not to waive, future requests or other types of impacts that are tethered to whatever the subject matter of the change might be, right? So it's very contract specific, but there are ways to kind of get through that. And I don't know. Oh, okay. Now it looks like the questioner has put this question in in a chat because he couldn't unmute. Okay, it says, if an ACO eval of a progress payment is delayed, assume that a payment delay, that there could be a payment delay and that there would be a potential for interest. Yeah, I mean, look, if there's not, if you weren't paid promptly on something, I mean, again, it's very contract specific, so we would need to take a look at your contract. But yeah, I mean, typically if the government doesn't pay due to their own delay, then you would be able to claim interest on that. Okay. Any other questions, guys? Going once, going twice. Let me just say, please contact us. You have our information here. If anything comes up that you'd like to discuss, we are here. We are happy to chat with you. And we really do hope that you've found this session useful. We decided to offer it just to kind of help you guys navigate the maze that some of you might be here. Well, wait, it looks like there's another question. Oh, it says thank you. You're welcome. You're all very, very welcome. Thank you all so much for everything, guys. Really appreciate your time. Okay, and you guys take care. Have a great weekend.
All right. Happy Thanksgiving.
Thank you all for joining us today. We hope you enjoyed the program. I just posted a feedback poll. Please tell us how we did today. We hope we did well, but if we didn't, we would like to know. All right, you can email me or you can email Franklin or Alex, and I'll make sure that your questions get answered probably by Franklin and Alex. So go ahead and email me with that. And thank you all. We hope to see you again soon.
Great. Thanks, guys. Take care.